Welcome back, everybody. As the last folks kind of filter back in, we're going to turn our attention to a discussion on the parental rights in education. This panel of expert attorneys will discuss the opportunities and challenges of bringing parental rights cases, plus how state legislatures are shaping the future of the parental rights movement. Please join me in welcoming our moderator, Ben Gibson, who is the chair of the Florida Board of Education and a partner at Schetz & Bowen.
Thank you so much. Well, this may be the last panel of the day, but I think it's probably the most interesting. And that's because I think, as everyone here knows, we have a crisis right now in public education that has emerged over the last 10 years. And especially since COVID, where parents are realizing that some of the most important and fundamental decisions relating to their child's education, and now even their children's health, both physical and mental health, has been outsourced to government schools. Worse, in many cases, schools have adopted policies that are now hiding information from parents about their own children in the guise of protecting children. Essentially, the government has decided that it knows how to raise and educate your children better than you do. And this has caused really a great awakening in this country related to parental rights in education, especially around the areas of race and sex. This panel today is starting with the premise that parental rights are a fundamental right, as the U.S. Supreme Court has said, and a basic common sense concept undergirding Western civilization, that in all except the most extreme cases, parents know what is best for their children. And today we have a fabulous panel of individuals who are literally on the front lines fighting this battle. We're going to define what the problem is, how it is being addressed in federal and state litigation, how state legislatures and governors are enshrining parental rights into law, and finally, hopefully we'll end on a positive note of what we all can do to protect parental rights, which ultimately means protecting our children from those who want to impose their radical agenda on the next generation. So now allow me to introduce our panelists. Starting directly to my left is Will Estrada, who serves as senior counsel for the Homeschool Legal Defense Association. He previously served on the Parental Rights Foundation as their first full-time president from 2021 to 2023. He also previously served in the Office of Conscience and Religious Freedom Division within the Office for Civil Rights at the U.S. Department of Health and Human Services from 2018 to 2021. And Will is going to today discuss the state of law on parental rights and legislative efforts in the states to recognize those rights. Directly next to Will, we have Luke Berg, who is a deputy counsel with the Wisconsin Institute for Law and Liberty, also known as WILL, and he litigates cases involving parental rights, election law, the First Amendment, and separation of powers, among other topics. Before Luke joined WILL over 5 years ago, he served for nearly 4 years at the Wisconsin Department of Justice as a deputy solicitor general, and has argued 11 cases before the Wisconsin Supreme Court and 6 cases before the Seventh Circuit. He's a graduate of the University of Wisconsin and got his law degree at New York University and served as a law clerk for Judge Diane Sykes on the Seventh Circuit. And he resides in Madison, Wisconsin with his wife and 3 boys. And then next we have Bernadette Broyles, who is the president, general counsel, and founder of Child and Parental Rights Campaign, Inc. She is an experienced family law litigator and a guardian ad litem, and has been an advocate for student privacy, parental rights, and Title IX protections in public schools. She has practiced as a commercial litigator and as a state prosecutor with the Fulton County, Georgia District Attorney's Office. And Bernadette was appointed by Georgia Governor Sonny Perdue to the State Board of the Georgia Department of Human Services for 5 years, where she co-chaired the Department of Family and Children's Services Committee and gained insights into state child protective services. She's also served on advisory boards to the U.S. Department of Justice Violence Against Women Program and the Juvenile Justice and Delinquency Prevention Program. And she and her husband have 2 children, and Bernadette has been literally on the front lines fighting these battles for parental rights. And today she is going to be discussing the federal litigation and legal landscape involving parental rights. And then last but certainly not least, we have Thomas Vasilou, who's an associate at Consovoy McCarthy, and also technically my lawyer in a few cases, where he assists clients with a variety of litigation and appellate matters. Prior to being at Consovoy McCarthy, Thomas was a law clerk to Judge Andrew Oldham on the Fifth Circuit and to Judge Richard Toronto of the U.S. Court of Appeals for the Federal Circuit. He is a graduate, earned his JD from the University of Pennsylvania, and not only is he a lawyer, but he's also very smart because he got his bachelor's degree in electrical engineering, summa cum laude, from the University of Florida. Go Gators. He is going to be our designated skeptic on the panel, which we all need, and we'll discuss the shortcoming of some of the cases. Is our strategy working or not? And sort of where we see ourselves going in the fight for parental rights. So first, Will, let me start with you. A lot has changed in the last 4 years, especially since COVID. We've had a lot of victories in the arena for parental rights and education, particularly, obviously, since COVID. Set the stage for us. When we talk about parental rights, that's a pretty broad term. So can you break down the specific areas where the battle for parental rights is occurring and give us an overview of the current state of the law as it relates to parental rights and where individual states are in their efforts to recognize parental rights?
Well, Ben, thank you so much. It's a privilege to be here with all of you and to really kind of set the stage of what Ben said and prepare this for this panel. We have to really start at the beginning. And I recently just wrote a law review. It just came out at Liberty University in their law review. It's titled Homeschooling in the United States, a Seismic Parental Rights Victory. And what I did was I started in the beginning. And those are, of course, are the words that the Jewish and Christian scriptures begin with. And I looked at the three great Abrahamic religions, Judaism, Christianity, and Islam, to say, what did they say about parental rights? And all three are in agreement that these are rights that come from God with the establishment of the family, pre-political rights. And some of you may know Melissa Moskela. She is a very accomplished writer and academic over at Catholic University of America. She's written about this. She calls them pre-political rights, that they predate government. And when we're talking about parental rights, where the current state is, where the tension and the debates are, what we see in the news all the time, I think it's very incredibly important to start with that our rights come from God, they come from the higher power, they predate government, and that really sets the stage when it comes to education, parental rights, medical decisions, when it regards parents and their minor children. So I started with that. I go through the Greek philosophers. It was, interestingly enough, the Greek philosophers where we first began to see some of the tension of parental rights. Plato, in his Republic, he talks about the ideal democracy, the ideal republic, the guardians, and he said that the families should be in common, the wives should be in common. He actually said children with disabilities should be left to die. There is a debate among Greek scholars of whether he was joking or whether he was serious, but Aristotle had the opposite view, that, again, the family comes first, and that's where parental rights first start, and then society comes after that. In the law review, then I go through the church fathers, I go through the English common law writers, and really come to then the United States, why we don't see parental rights in our Constitution, because our founders all agreed that they come from God. We didn't need to put them into the Constitution. And that was really where things were for the beginning of our nation. It wasn't until the early 1900s that we began to see the precursors of the battles that we have today regarding parental rights. I go through this in the law review, and it was really not until 1923. And what was the case that we had there 101 years ago? That was Meyer versus Nebraska. This was the first time that the United States Constitution, or the United States Supreme Court, had to deal with state laws versus parents. And it came in the post-World War I anti-German sentiment. Of course, you had anti-Semitism going on, xenophobia, bigotry against Roman Catholics. And so Nebraska had passed a law saying parents couldn't teach their children any language other than English. And of course, we all know where that went up to. The Supreme Court was Meyer versus Nebraska. And that was the first time that the U.S. Supreme Court struck down a state law and saying, because parents have a fundamental right. So when we're talking about parental rights, fundamental rights, this highest right for parents to be the ones to make the decisions over their children, that's where it all started in Meyer versus Nebraska. 2 years later, and again very importantly, the battles that we see as a precursor for today, Oregon, the Ku Klux Klan had been involved in this, a law banning private schools. Today, private schools are common. No one even bats an eyelid. But 100 years ago, those were the battles for parental rights. And of course, that was Pierce versus Society of Sisters, where the Supreme Court said that the child is not the mere creature of the state, and parents are the ones who make these decisions. That's the heritage of where we came from. 100 years ago, the battles were over whether private schools could exist. Then I go through the history of homeschooling. In the 1970s, the battle was whether parents could choose to homeschool their children. And today, when we look at where we are, those battles are pretty much done. Parents have won the right to have their children in private school. They've won the right to homeschool. We heard from Governor Youngkin. Twice he referenced homeschooling. And today, Ben, in answer to your question, the battle is really over the issues of medical decisions and public schools. How far do parents have the rights in the public schools? And this panel is going to be looking at some of those cases that I think are on their way to the U.S. Supreme Court of how far those rights are. One other very interesting thing is that's kind of the Supreme Court and appellate court level right now of where parental rights are, but what's going on in the states. And a lot of the victories for parental rights have been at the state level in the past 10 to 15 years. 27 states have passed laws saying that parental rights are a fundamental right. This is critically important because, yes, we have the U.S. Supreme Court that parental rights are a fundamental right, 14th Amendment, substantive due process. We can have a debate where that should be, but that's essentially where the court has come down for 100 years. But then protecting this at the state level oftentimes provides even more protection. So you have laws like in Florida's, where in 2021 they passed the Parents' Bill of Rights. You have a couple states out in the Midwest where they've actually established a private right of action where parents can sue if they believe their parental rights are being violated. But this has been one of the most exciting areas of success for parental rights. That's about where we are right now, and I'll pass it on to Ben to bring up the next speaker.
Thank you, Will, and thank you for laying that out. Medical decisions and public schools, two of the places where the battle is being fought right now. Luke, let me go to you now. We are literally in a brave new world. I think if you looked at 10 years ago, just 10 years ago, if you would have thought about the types of battles that we're fighting in our public schools, it would be unheard of. And now parents are having to combat secret gender transition policies in schools. For those who may be unfamiliar with these policies, can you explain what they are and more generally talk about the state level litigation that has emerged challenging school district policies that are hiding gender identity transitions at schools from parents?
Yeah, well, thank you so much for having me. Thank you for the organizers for including this topic in the discussion. I'm biased because I'm passionate about this, but I think this is one of the most important civil rights issues of our time, so I think it's timely, obviously, and a very important discussion. And thank you for you all for powering through to the afternoon session. I know it can get long sometimes. So what I wanted to do is just kind of set the stage for what we're talking about, give an overview of what the kind of current battle is against school districts. So the policies that we're talking about at their core, they allow and facilitate minor students, often of any age, changing their gender identity at school, so their names, their pronouns, bathroom use, locker use, without involving the parents in any way. That's sort of the heart of the policy. And then there's a variety of variations. So in a lot of school districts, it's nothing more than that. We will do this without involving the parents. In some school districts, they actually prohibit teachers from telling parents. So if a teacher wants to tell the parents, they cannot. Some school policies prohibit teachers from answering truthfully if a parent even asks. There are some school districts whose policy requires teachers to hide records of the transition, to keep it in confidential files, which is actually a violation of federal law. And most egregiously, some school districts require teachers to actively deceive parents by using one name at school, and then when the parents show up or in communication with parents, use a different name so that they can't figure out what's happening at school. So in Madison, where I live and send my children to school, they have all of these aspects of their policy, and I have sued the school district over them. So effectively, we are treating school as if it is Fight Club. Do you remember that movie? What's the #1 rule of Fight Club? We don't talk about Fight Club. I never would have thought 10 years ago that this is where we would be today. You would have been labeled a conspiracy theorist if you thought that, schools would be hiding things from parents, but this is where we are today. So how prevalent is this? There's a group called Parents Defending Education that has been documenting school districts that have these policies. To date, they've discovered over 1,000 school districts across the country, covering nearly 12 million students. Stories of this are popping up all over the country. By my count, there are 35 to 40 lawsuits. Often the facts are parents find out months after the fact. that their child has been being addressed and treated at school as if they're the opposite sex without their knowledge. And I think these estimates are probably an underestimate. In a number of the cases, the school district didn't actually have a written policy. The parents didn't find out that this was the policy and couldn't have found out that this was the policy because it wasn't written down until it actually happened to them. So I think it's a lot more prevalent than even those estimates, which are already quite high. So maybe you don't need to be persuaded why this is important or why this matters, but I just want to tell a story that I think will really put a point to it. And this is the daughter of one of the clients that we represented in a case that we won against the Kettle Moraine School District in Wisconsin. So our client's daughter was 11 at the time. She's kind of outgoing, enjoys spending time with other people. So in the midst of COVID, as I think many students experience, she was lonely, she started to get depressed, she started to get anxious, and this spiraled into eventually questioning her gender, herself, who she was. So she started to have some questions about this. She first told one of her friends at school, who then told a teacher, and the teacher came to her and said, hey, we can change your gender at school, your parents don't need to know. And the 11-year-old had more sense than the teacher did and said, no, I think my mom would be mad about that, we need to involve her. So they involved mom in this situation. This doesn't always happen, as Bernadette's going to talk about. So they involved mom and sent her to an outpatient mental health facility to deal with a lot of the depression and anxiety she was facing. When she got there, the psychologist immediately said, yep, you're a boy. The sooner you transition, the better. And your mom is going to be your worst enemy. Because she's not going to be on board with this. So this is something that we see frequently, that there's no processing, there's no question, it's just immediate affirmation by mental health professionals as well. So pushed by, I think, the school staff and her friends and this psychologist, she decides, yep, I think I want to transition, change my name and pronouns, tells her mom, tells the school. Initially, mom says, okay, this is throwing me for a loop. I wasn't expecting this. I'll say okay for now, but I'm going to research it. So she researches it and decides, I'm not saying no, never, but this is a major life decision. So I want you to take time to process this before and deal with your psychological issues before you make this major life change. So I'm going to say no for now. And I'm going to tell the school district, when you go back to school, I want them to refer to you using your female name and pronouns. The school consults with their lawyer and says, sorry, we're an advocate for the student, not for you, the parent. And if you send her back here, we're going to call her whatever she wants, not what you want, parent. So she does what I think any parent would do in that situation. She immediately pulls her from school. She immediately pulls her from the mental health facility. She pulls her from social media. And you can imagine there was some tension in the home for a while. But 3 weeks later, her daughter walks into the kitchen and says, Mom, you're right. This is not actually who I am. I was confused. And having all of the adults around me affirm that I was a boy actually made it worse, confused me further. And so now she is very well established in her identity as a female. And she has told me since that if it hadn't been for her mom having the courage to do what she did, she's not sure she would be here today. And so I just tell you that story because I think it highlights that this is the experience for at least some. Whatever you think of this issue, for at least some young people, this is a psychological issue that they're dealing with. They're confused, and they don't need all of the adults around them saying, yes, this is really who you are, you're the opposite sex. They need someone who loves them and has the courage to stand up to them and say, this is not true of you. You are beautiful as you are, and I'm going to love you no matter who you are, but this is not true of you. And that takes courage and love, and that's the only kind of thing that a parent can do. And that's why it's so critical that we not hide this from parents, because if it had been hidden from them, she would be far down this path. And so this can do a lot of damage to young people. So I hope that just highlights why it's so important that we include parents. So as Will talked about, the right that all of these cases are brought under is parental rights, which is grounded in substantive due process, 14th Amendment, which we know is not favored anymore under the current court. But it's pretty well established. There's a handful of cases, it's not a lot from the US Supreme Court, but it's a handful of cases that Will talked about. And the court has repeatedly said that the 14th Amendment protects this right, and it articulates it pretty simply that parents have the right to make decisions concerning the care, custody, and upbringing of their children. So often what happens then is, this right would get litigated in lower courts, but I think that hasn't happened in part because there just haven't been a lot of factual situations where government has infringed this right historically, and that's a positive thing, but what it means is there hasn't been a lot of development of this right, fleshing it out, what is the scope of it, how does it extend in the lower courts until now. And all of a sudden now we have these actually two issues that are being litigated at the same time, and there's just a wave of litigation over parental rights. And what's particularly interesting about this to me is that it's on the same topic and it's happening in the opposite direction politically. So the one that I care about the most and that we're talking about here is in schools, where schools will hide gender transitions from parents, and the parental rights claim is we as the parents have a right to decide whether a transition is in our child's best interest. Simultaneous to that, there is a whole separate thread of cases challenging state laws that ban puberty blockers, cross-sex hormones, and surgeries on minors. And one of the main claims in these cases is a parental rights case. And the framing is we as parents have a right to make a decision about whether a transition is what's best for our child, right? If you frame it that way, that sounds like exactly the same claim in opposite directions politically. So it's going to be really interesting to watch how this plays out in the courts, because I think every judge is going to have different intuitions about each of these two issues. Now, to be clear, I don't think these are equivalent claims at all, and I think one should win and the other should lose. And I think if you think about it for more than a minute, it's not hard to see how they're different. So in the school district case, you have government stepping into the shoes of a parent and making an individualized decision about a particular child and what's best for that child. I think that, if anything, is a clear violation of parental rights, that is. Whereas in the other case, you have a state law that's regulating the medical field, and that's pretty standard historically. But the interesting sort of intellectual thing that this raises is how do we think about this substantive due process right, and how is the court going to think about this substantive due process right now that it is skeptical of substantive due process? Is it going to confine it to the facts of prior cases, or will it allow some level of abstraction? I mean, if you confine it solely to prior cases, then it's a meaningless right and it can't apply to any new facts. If you allow some level of generalization, then it can cover new situations, but how far do you abstract? And it's not clear to me how the court's going to think about that, but it's going to just be really interesting to watch, given that you now have this massive litigation that appears to be arguing the same right on opposite sides of the political aisle. So the one last thing I want to say, just to kind of set the stage for our discussion, there are kind of two kinds of cases that get brought challenging these school policies. There are cases brought by parents preemptively against the policies, where they have no reason yet to believe that the school has actually transitioned their child, but the policy says explicitly, we're going to make this decision for you when the issue arises, and we're going to hide it from you when we do. And so parents naturally think we need to challenge this in advance so that if this happens to our children, we will be involved in the decision making. So that's sort of preemptive challenge to these policies. And then there's a series of cases, and Bernadette is going to talk about a lot of these because she's brought a lot of them, that happen after the fact, where a parent discovers that the school district has secretly transitioned their child, and then you sue for damages or other remedy after the fact. So I have litigated 3 of these cases, 2 in the preemptive posture and 1 in both postures. And the preemptive cases, in the main, have all lost on standing, with the exception of one that we brought in state court. But for the most part, they've all lost on standing, which is the idea that parents are not injured by these policies. They haven't actually been harmed until they have evidence that their child has been transitioned secretly. Now, I think this is wrong under standing law. I think it's crazy. The whole point is if a government entity says, here is exactly how we're going to violate your rights, and we are going to actively hide from you that we're doing so when it occurs. And now we have numerous examples of parents who took them months to find out that it had happened, and horrible things have happened in the meantime. You have to have standing to challenge that in advance. But so far, most federal courts have said no. So we currently have a cert petition pending to the U.S. Supreme Court on one of those cases. We sued the Eau Claire School District. This school district has this policy. It actually conducted a training for all of its teachers, and in his training said, remember, highlighted this emphatically, remember, parents do not have a right to know their kids' identities at school. They must earn that right. And we, the school, are the arbiters of whether they earn that right or not. So that's the facts, which you think would be a good case for standing, but district court said no standing. You don't even get past a motion to dismiss. You don't get to do any discovery about whether your children have been transitioned. We lost at the Seventh Circuit, which ignored most of our arguments, and so now we have a cert petition pending to the U.S. Supreme Court. It's a long shot. Normally you want a split among the lower courts. There isn't that yet, but we try to paint the picture of the story of what's happening around the country and how this is harming young people. Obviously, it affects millions of young people. So we hope there's some chance that it gets granted, but we'll see.
There's a lot of good stuff in there, and I've got like 10 follow-ups, but we're going to come back to on those, especially where you talked about where's that line between when we talk about this battle of parental rights, because between on the education front and then looking at the puberty blockers and cross-sex hormones, where a lot of states have put in bans, and that's an interesting thing that I think we'll come back to. But let me go to Bernadette now. Bernadette, there's also been a lot of litigation at the federal level. Can you tell us some of the stories of parents that have fueled this litigation and where we are on the federal level in regards to litigation over parental rights?
I'll be happy to. I am so pleased to be here. I would just slightly quibble with one small thing said, in that aside from the rights of preborn children to be able to live and to be born, I believe that the rights we're talking about here today are the most important rights in our nation at this time. I think they have catastrophic national consequences if we don't begin to get this right. And I would go ahead and say this. We are at an inflection point in our nation where a question that we had thought was settled about 100 years ago by the Supreme Court in what we all know the case of Pierce versus Society of Sisters is now an open question. And that question is, are children, after all, the mere creatures of the state? It used to be a foregone conclusion that it was resoundingly no. It is no longer at all clear what our policymakers, what our school officials, what our government officials, whether they actually recognize that it should be no. And particularly when a child begins to declare an assumed sexual identity. By the way, I encourage us all never to use the word gender. Gender is a made-up term. It corresponds to language. I speak Spanish as well as English. And in Spanish, the gender of the language makes a difference. But it's been co-opted by activists to try to create the legal fiction that there is something real that is not real. We have sex, male and female, and that is it. So I always say sexual identity. But in any case, so here are the real-life consequences when government school officials presume that the answer to that operative question I just asked are children the mere creatures of the state, when they presume that the answer is yes. Here are some of the real-life consequences. I'll just talk about a few of our cases. We have right now 6 cases pending in federal court, but our first case was the Littlejohn versus Leon County School District. I believe, I could be wrong, these two follow this more closely than I do. But I think our case of Littlejohn, Jeff and January Littlejohn versus Leon School District, was the first federal parental rights case that was brought. And in that case, a middle schooler began a typical thing, peer pressure, internet access, began to express sexual confusion. Listen to me, I'm still working on it, to her mom. And mom was the teacher of the year at the middle school. So she trusted the favorite teacher to kind of share this and to say, hey, listen, such and such, our daughter is having some confusion. We're okay with nicknames, but beyond that, no pronouns, nothing else. We're not on board with that. And the trusted teacher took it upon herself to run with it, took a number of steps that culminated in this. I believe she was 13 years old, but she was on the autistic spectrum. That's a flag right there, very typical. To find herself meeting with several adults in a room by herself. Her parents had no idea, in which they completed a 6-page written gender support plan that asked such things as, do you feel you're a boy or a girl? Which bathroom do you want to use? With whom do you want to room during overnight field trips? And most importantly, then finally, do your parents know, and do you want them to know? Do you want them not to know? Well, parents find out about this, and ultimately we end up filing a lawsuit concerning their outrageous behavior. Thankfully, in that case, there was a school policy, so we didn't have an issue of standing because we had an injury, but there was a school policy that got us past Manel. That case right now is pending before the 11th Circuit Court of Appeals. In the Perez case, so Maria and Wendell Perez show up at school, were summoned to school, to see their daughter in the back of a police car being carted off to a mental health facility, only to find out for the first time when they talked to the school principal that their daughter, 12-year-old daughter, had been expressing gender confusion at school and had been meeting privately for weeks with a woke school counselor who conspired with the child not to tell the parents deliberately because they knew that the parents were committed Catholics, Hispanic, by the way, and would not agree. This child became so conflicted, her mental health descended rapidly, didn't have mental health problems prior to this. Her mental health descended so rapidly and so precipitously that with the conflict that she actually did legitimately attempt suicide in the school bathroom. Thankfully, it was not successful, and they immediately took her off to a mental health facility. Now, that case is pending right now in the Middle District of Florida. One of the last cases I'm going to tell you about, we have others, but is even more, as difficult to bear as that one is, it's even more tragic. This is, I will tell her name because her name has become famous. She stands for a bill they're trying to pass in Virginia, Sage Blair. Sage was a young high schooler. She had had trauma in her life from her young life and her early childhood. She began to trans-identify when she began to express puberty. She was bullied at school, and the counselor encouraged her to use the boys' bathroom because now you're a boy, where she was bullied further and then sexually assaulted by boys in the bathroom. None of this, all of this was withheld with them parents, had no idea this was going on. Her situation became so bad, she was being threatened by these boys, that she decided to run away. She actually was to protect her parents. And when this little girl ran away, she ran right into the arms of a pedophile who raped her and trafficked her to other men. This little girl had never kissed before, prior to this. It goes on, it actually goes on and on, this story. She ended up being trafficked in multiple states, and et cetera. But here is, see, to me, this is not academic. Yes, we have to have an academic discussion, but these are the real lives that are being destroyed, and the families that are being destroyed by an ideology that has infected our school system and causes them to presume that our children are theirs. So I want to real quickly run through the legal gauntlet that parents have to run through in order to vindicate their parental rights. I'm going to try to remain very superficial for in the interest of time. First of all, they have to get through Manel, the Manel Doctrine, right? 1978 case that basically said it shields school boards from liability and municipalities, but school boards from liability unless you can prove that the school district had a policy, custom, or practice in place that caused the violation. The problem is that the courts are requiring very detailed proof of a policy or custom at the pleading phase. And the problem is that the school board, as Will already talked about, they control the information that they are purposely withholding from parents. So when you couple that with a narrow interpretation of policy or custom, the courts are creating a de facto sovereign immunity that shields these school boards from liability at the motion to dismiss phase when it's supposed to be notice pleadings. Parents must be allowed discovery, and that's what we practitioners need to begin to really pound and argue. Otherwise, if they're not allowed to proceed with a well-pleaded complaint, you are going to be wholesale depriving parents of the ability to vindicate their constitutional rights in court. And you are going to reward perverse, bad behavior by government officials. What are parents going to be left with after this? Guns? Seriously, if they cannot vindicate their rights in a civilized way. The second, then, if they can get past Parental, which our cases do, and it's been harder for some others, then they have to traverse qualified immunity. Qualified immunity has two prongs, right? You have to prove that the right is clearly established so that a reasonable school official will recognize that what they're doing, it would be violating a statutory or constitutional right. Typically, most courts don't get past that first prong. The second prong is whether there actually was a violation of a constitutional or statutory right. Most of the time, they don't even get to the second prong because the clearly established is where parents are falling into this pit. And it has everything to do with the level of particularity that the courts choose to take. If they don't want to find that there is a violation of parental rights, they just zoom in with great focus, great granularity, and just say, oh, this case is just too many details that have never been established in law. And qualified immunity is a real problem. But if you get past that, then you have a third pitfall, and that is the shock the conscience test, where in federal court, you're bringing substitute due process parental rights claims. And so it is unsettled whether under Sacramento v. Lewis, Supreme Court case back in the 90s, there remains a separate test for when the violation is of a fundamental right versus just some more run-of-the-mill substantive due process right. There is a difference. So in that unsettled world, you have now courts are elaborating a distinction between legislative actions versus executive actions. So if the action taken can be described as a legislative action, then they apply strict scrutiny. But if it can be described as an executive action, then they apply the shock the conscience test. And here's the clue. If you apply shock the conscience test, 9 times out of 10, parents lose. If you apply strict scrutiny, they get to go. And so, again, practitioners in the room, we need to start attacking that distinction between executive and legislative. That's a violation of separation of powers. How is it that if you're an executives get to violate constitutional rights where legislators don't? That's nonsensical. All right, so let me close with this last thought. When courts reward school officials that trespass the boundaries of parental authority over their children while engaging in secretive behavior, that they claim ignorance of knowing that it violates fundamental parental rights, courts are effectively allowing children to become the mere creatures of the state. What's so perverse about this is that you can't give a child an aspirin in school, yet you claim to be ignorant that treating a child as something other than the sex that their body is created and all that implies is you somehow, I can't figure out that that's violating a parent's rights. The reason why this is the most important civil rights of our time, and I will yield my time after this, is a government that can take over our child's belief system, a government that can take plenary authority over our children will become inevitably a tyrannical government. It is what the Nazis did. It is what China does. It cannot be allowed in our nation. So I'll yield my time at this point. Thank you.
Thank you so much, Bernadette. Let me go to Thomas now. And we've talked a little bit about litigation on the state front and the federal front. Luke talked about the issues with standing. Bernadette talked about sort of the federal gauntlet that you have to go through, the difference between legislative and executive action, and the type of standard that's going to be applied. We also know that bad facts make bad law, and sometimes courts want to see these issues sort of percolate, and so you can bring these cases too soon. Talk a little bit, you've been involved in litigating these parental rights cases. Talk a little bit about what you see from the national landscape and on a state level basis, the strategy that people who are bringing these cases are employing. Do we have a good strategy? Have mistakes been made? And are we winning the fight?
Well, thanks for everyone for having me, and pleasure to be last on this, because I think a lot has been covered. I think Luke covered a lot how we haven't really had success so far. When we bring facial challenges, parents are held to lack standing, and when we bring as-applied challenges, as Bernadette spoke about, there's several hurdles where there's qualified immunity, there's this shock of conscience standard, and the like. So what cases do we bring? I mean, it's been, I think, 4 or 5 years since the first case was brought, maybe even more. We've yet to have a Circuit Court of Appeals issue a positive decision on the merits on any of these cases. We have at least 2 that have said no standing. And it's, Luke mentioned a little bit earlier about that this is a substantive due process claim. Now, other people have brought other types of claims. I generally like to think of maybe 4 types of parental rights claims that I can think of pretty quickly. Luke covered 2. That's the parental exclusion policies, the social transitioning behind a parent's back. You have the child protection laws out of, say, Tennessee, which the Supreme Court is hearing this term, although they didn't take the parental rights question. They only took an equal protection question. I've seen curriculum challenges. This is sometimes a free exercise challenge, but it's also been sort of a hybrid, right, of a parental rights challenge. I believe Beckett has one of those, and I think they're seeking cert before the Supreme Court at any day now, if not already. And the last of a recent case I've seen is sort of the overnight accommodations bathroom cases where they're asserting they should have been informed before our child went on a trip and shared a room with some of the opposite sex who identifies as the same sex as their child. I think we've mostly talked about the parental exclusion and child protection laws. I think those are probably the more litigated. There's been early curriculum challenges, and those are almost always rational basis questions. And as Bernadette said, if you're under rational basis, you lose. But I think there's sort of 2 things I'll just go and touch on when thinking about through the merits question on these. So the first is there's actually a lot of circuits with precedent, more than you would think, and most of it is negative. The fact is that Pierce and Myers were before we even had scrutiny levels. It was before its even existence. And a lot of people brought dress code challenges in a lot of the circuits. And dress codes are fundamentally different than the horror stories, the important medical decisions that everyone else has talked about today. But the fact is they've interpreted these, key parental rights cases, and there's very few of them from the Supreme Court. I believe the most recent is 2000. It didn't even get a majority opinion. It was plurality. They didn't decide a scrutiny level. And Luke spoke about, well, if our choice is scrutinies, which there's debate whether we should do it, is it going to be strict scrutiny? Is it going to be rational basis? And how do we draw that line and what sort of guides us? What's the level of generality of the rights? And then also the level of generality of right and what's supporting that right? What's the history? As far as I'm aware, and anyone can correct me and point me into the right article, and I would love to see it, there's not that much history of parental rights as it intersects with the school, and I don't mean private school, homeschooling, that type. I mean, when it comes to in loco parentis, there's not a lot of history of the scope of it. And we've seen the Supreme Court debate about it in a case called Mahanoy. And so some of the trouble and maybe that we're going through is a lot of these cases haven't reached the merits. They've been stopped earlier for other doctrines. And so we haven't really moved forward on that stance. But at the same time, the way to move forward on the as-applied challenges, the harm to kids already being done, is to bring facial challenges, because that establishes the law that would then get us past qualified immunity and the like. And so it's not clear what the strategy is, because both cases are happening at once. And there's good reason for that, because when tragedy happens and you have a good claim, you should be bringing the claim. The other part of this is most of the cases are being brought where states are allowing these types of policies. And those states are generally in circuits that would not be favorable to either a substantive due process claim or just the claim in general. And it's resulting in, when I'm thinking about bringing a new case, and I'm sure my colleagues will think about this or have thought about this when they bring a new one, they're getting stacked up. Oh, here's 5 cases that disagree, and are you, the district court, going to go out of your way and go against these 5, 6, 7, 8 other courts and find standing here or find a violation of parental rights? And each time we litigate in those other circuits, it becomes increasingly more difficult to get other circuits, other judges, to do what I think is the correct answer, which is declare that this is a fundamental right, strict scrutiny applies, and that applications and these policies violate the Constitution, and families should be getting damages when they're applied to their children. But we haven't seen that happen, and I think Luke said there's about 35, maybe 40 of these cases, and I'm wondering how many more we need to get to that next step. It's been 4 years, and I think there's something missing here, and it might not be in a strategy point. Maybe it's just time. Lil John is still pending before the 11th Circuit, but there really needs to be a catalyst, sort of a big win, to make me think that this movement is going to ultimately win in the end without having state laws or other types of legislation move the dial.
So Little John is, you mentioned that, both Bernadette. That's where the school district in Leon County, where I live, where my kids go to school. One thing that obviously the case is still going on, but one thing it was able to do is spark state action in Florida. And she's been a champion, and not only in Florida, but it's happened in many states. I know, Will, you talked about the number of states that have passed Parental Bill of Rights, and we're sort of seeing this take off. Question for you, Thomas. In these states that are doing it right, that are putting in protections for parents, have a Parental Bill of Rights in place, are there enough avenues under state law that you're seeing for parents to be able to bring actions because you might have a great, in Florida we have a great sort of state level policies, but then you obviously have a bunch of districts and stuff too, and sometimes they'll run afoul of it. So when a parent sees it, are there enough avenues on the state level for them to be able to bring cases?
I haven't surveyed all. I think Will mentioned 27 laws on it. I know not all of them have a private right of action, which means I get to sue enforcing my rights. Sometimes I have to argue that there's an implied right, as in I should be able to bring one even though the statute doesn't say it. Other times, though, the problems with the state law is I'm going to have to be in state court. A lot of litigators prefer to be in federal court, and one reason you might not be able to go to federal court is sovereign immunity. A lot of states would not allow to bring a state claim in federal court. Other parts of it is, litigation is very costly, and my understanding is not a lot of them have prevailing party provisions for attorney's fees. And by prevailing party, normally it's just if the plaintiff wins. Otherwise, I think that would also discourage if the plaintiff is risking for a non-frivolous case to pay the attorney's fees of the school or the teacher or the state. So I think there hasn't been uniformity in them, which can be a good thing and a bad thing. But as far as I know, I don't believe Luke's case in Wisconsin involved a state statute. It was just in the state court, and that's the only merits decision I'm aware of. That was
So if you don't have somebody like Luke and his organization litigating on your behalf, Luke, what do you think? Are the prevailing party attorney's fees, is that something crucial for state lawmakers to be putting in these parental Bill of Rights?
Look, I'm a public interest litigator, so it's helpful. But
One-sided, right?
yeah,
One-sided.
so I just wanted to go back to the prior question because I'm a lot more optimistic about this. We're going to win this in the long term. I really believe that.
I agree.
And I think we are winning it. The cases so far, there's been more losses than wins for sure. But I think the problem is not bad facts make bad law. It's bad judges make no law. What's happening is we've just gotten a bad pull of judges who are just avoiding the merits in these cases. And the parents who sue preemptively, they're getting kicked on standing. And the parents who sue after it harms them, they're getting kicked on qualified immunity and kicked on shocks the conscience and kicked on Monell. And there's very few judges who are actually saying, yeah, it's totally fine for a school district to completely disregard the parents and make a decision for a child that's a significant lifelong medical decision. There's a few, but not a lot have said that. And I can't believe that once this all shakes out, that like federal courts are unanimously going to say, yeah, no problem, go for it, make decisions for parents. So I think it's only a matter of time. There have already been a number of wins in federal court. Oddly enough, most of the wins have been brought by teachers who are forced to lie to parents, and they bring a First Amendment claim. So it's clean. It fits into a box that courts recognize, which is, I think, why they've won. But I think that sort of calls attention to like something has seriously gone wrong with the federal judiciary if teachers can win these claims, but the parents, who are the primary injured parties, cannot. And that's part of what our cert petition tries to call attention to. But I just think eventually we're going to win, and we're going to get enough wins in court that the U.S. Supreme Court is going to have to weigh in eventually. But in the meantime, it's spurring legislative change. So a number of states have passed laws in response to the stories that are told in these cases. School boards have flipped because of these issues.
Yes.
Governor Youngkin won on parental rights issues. So I just think this is an issue that polls heavily in our favor. The stories are compelling. Last thing I'll say before I shut up, I live in Madison. I litigate a lot of conservative issues. Madison is not exactly a bastion of conservatism. But I've talked with a number of families in our school district who have said to me, I know what you do, I disagree with everything you do, but I agree with you on this case. And that's shocking in a heavily progressive city like Madison, that somebody would say, look, I might transition my child, but I would want to know. So I think we're going to win.
It seems
Yeah,
pretty
and-
common sense. Bernadette, your thoughts?
Yeah, I wanted to jump in on that. I think what we are doing is actually a game changer. And even if any individual case doesn't prevail, it is an absolute game changer because for decades we had been outsourcing our parental authority over our children. Then this didn't just happen overnight, all right? There are those that seized the opportunity that we gave them by virtue of the, again, outsourcing our parental authority to third parties. And what we've seen in all of these, if nothing else, our cases have accomplished is that it has caused a level of engagement of the electorate, of the citizenry, that I haven't seen in my personal lifetime. Now, and I will say on top of that, most of our cases are pending in Circuit Court of Appeals, and at any time, any of these could pop in the right direction. We got First Circuit, 11th Circuit, 4th Circuit, any of these could. And we do have one case, it's not, the facts are not as interesting, but legally, it's very interesting. We do have one case that has broken through, and that's the Willie case. And that's pending in Wyoming. And there, first of all, the judge did issue a preliminary injunction to stop the school district from being able to actively deceive parents. He was so bothered by that even though he ruled that whether it shocked the conscience that applies or not, and it's the other test, or executive, whatever, he said, you know what, I don't have to reach that because this shocks the judicial conscience.
It's amazing that you need an injunction to say don't lie to parents, right?
Yeah, and so when he did, and then now he has denied the motion to dismiss on the mom's fundamental parental rights claim, substantive process, coupled with her free exercise claim. So, and we're in discovery, and we're moving into trial on that case. So there are a number of prescriptions that it's appropriate to share what is at stake, the consequences if we continue to allow this slide. And that requires a little bit of shock, but absolutely, there's much that can be done, and as litigators, there are things to be done. On the legislative front, where is Ginny? Okay, I'm going to put up my sign again. Don't pass another parent's Bill of Rights unless it has a private right of action. Period. I'm going to put this as a sign that I wear everywhere. Because, yes, you can argue that there's an implied right of action, which we did in Little John. We've abandoned it. We knew we were going to lose. We abandoned it. It just wasn't worth it. And so for those wonderful states that have, go back to the legislators and get a private right of action in there with fee shifting. And then there are another number of prescriptions that I can share. I'm not sure if this is now
Right, because the rights aren't worth a whole lot if you can't enforce them, right? And if you can't exercise them. Will, let me go to you. You mentioned, I know you've done a lot of research with homeschooling. We've seen an explosion in not only homeschooling ever since COVID, alternative, school choice that has really, I think, been fueled by the idea of parents saying, listen, I don't have the same rights in public school, so I'm going to take my kids out of public school and move them into either private school or homeschool. Is that a viable option for us long term? Are we going to end up with basically sort of two sets, almost like our education policy is going to be the same as our politics, where if you believe one thing, you're going to send your kids to public school. You believe another thing, you're going to have to send your kids to private school or homeschool. How do you see this whole parental rights thing delving into the idea of school choice?
That's a great question. The first part of it is homeschooling is far more accessible than it was even just a decade ago. There are rises of what are called learning pods. Georgia actually just passed a law 2 years ago called the Learning Pod Protection Act. This is where just a group of families will come together. The moms and dads will share the education. There are a rise of micro schools, of pretty full-service co-ops that are under the homeschool statutes of state laws, but are kind of acting like private schools in many ways. So education is becoming more of the iPhone age, where instead of the kids being bricks in the wall, it's almost like apps and widgets, and people can pick what's best for their child because every child is different. One size fits all does not work, and we're seeing that in education. And when you think of education policy and what's moving on forward, we're seeing more of customization in education. It is a good question, though, because can every parent homeschool? Is every parent able to homeschool? Is that even best for every child? And we still do need to stay focused on the public schools, on making sure that private schools and homeschools are free, but that we can see reform in public schools. And I'll just be honest for a second. I'm not sure if the Supreme Court is going to save our bacon in all of these cases. I think there is, I'm hopeful, Luke and Bernadette, on these cases, but I do worry, and we have to be prepared if there's almost sort of a Dobbs approach of, well, we're going to leave it to the states, and if California wants to do one thing and Florida wants to do another thing, then we don't want to become the federal courts being the school boards. And part of the reason we're in this problem in the public school context is because a lot of the appellate court decisions and district court decisions over the years have said, yep, you have a right to private school, you have a right to homeschool, but if you're in the public school, we're going to kind of defer to the school boards. Now, again, a lot of these problems it's pretty egregious. You shouldn't be able to lie to children and hide things from parents behind their back if you're a government public school employee, but that's where some of the appellate court decisions have come down. And so to that question, one of the things we need to focus on, yes, we need to push forwards on the litigation, but just as good citizens, and I won't ask for a show of hands because I think it's going to be an embarrassing response, how many of us know who our school board members are? How many of us, okay, that's good actually, more than I anticipated. I'm encouraged. How many of us voted in the last school board? We have got to, those are very good numbers. This is a good group.
I don't think this group is representative of the general population.
Oh, shucks.
Can I just say something quick on that?
Sure.
So The silver lining of all this may be that it's hard to think of a faster way to destroy the public school system or catalyze school choice than this issue, right? I mean, if we lose these cases, right, if we get up to the U.S. Supreme Court and we lose these cases and the end result is teachers can make secret decisions for your children at public school, that is going to catalyze the school choice movement, right? And that may be the end result of all this, and I think that could be a positive thing. It's going to take a long time, but...
So Luke or Bernadette, or both of you, basically the idea of the secret, gender transition policies is the idea that if a parent decides not to affirm their child's choice, that somehow they're a danger or a threat to the child. Where's the line? Let's talk about the tension between that, where I think we would agree that a parent would not be a danger or a threat, to when the government does need to step in when there is a genuine threat. Where is that line, and how do you define it?
Yeah, that line has been established a long time ago with Child Protective Services. There's a long line of case law that delineates between a parent's appropriate authority versus when a parent takes actions that actually causes harm to their child. You cannot withhold a blood transfusion of your child when your child is going to die or suffer a catastrophic injury, as one example, and there are many, many others. And so to me, this is not hard. They try to make it hard and they try to blur the lines. It's not difficult. For a parent to be able to be allowed to consent to authorized interventions that result in their child loss of healthy body parts, interference with basic healthy development of the child's body and brain, results in sterilization, the deprivation of the ability to have children themselves when they're someday an adult. That is outside the purview of a proper parental authority. I would assert that is aligned with child abuse. And so, no, that should not be a proper assertion of the substantive due process right. And then hopefully the case that's before the Supreme Court is going to be able to make that clear.
Yeah, what I would add to that is in the most recent parental rights case, it's Troxel, the court said that there has to be a presumption in favor of the parent's decision, that the parent's decision is in the child's best interest. And government can override that presumption, but you have to provide due process, and it has to be a sufficiently high substantive standard, like clear and convincing evidence of abuse. And the problem with these school district policies is that they presume the exact opposite. They are based on the assumption that if we involve the parents and we defer to their decision, it's going to be a bad decision, and it's going to harm the child, and they're providing no process whatsoever. They're making the decision and hiding it from the parents, not even giving them an option to weigh in and say, here's why this is our decision. So I just think under the way the court has framed parental rights, it's the decision-making framework that matters. Parents are the primary decision makers. These cases should be easy. It's unfortunate federal courts are kicking them and avoiding the merits in a variety of ways, but I do think we're going to win eventually.
So what do you think is driving this? When you think of, I have 3 little kids. If you get parents who have school-age children are used to getting permission slips to go on field trips, to play sports. You have to sign a waiver for everything. Usually a lot of times if your child is going to be administered Tylenol, you have to sign something. What is unique about this? Why has a different standard developed as it relates to the idea of gender, and more in particular, who is driving it?
It is because a Marxist worldview has infiltrated our education system, particularly the academy, and teachers that are being trained, and psychologists that are being trained, and this Marxist worldview posits that children belong to the state. That's a fundamental aspect of that belief system. Now, it dresses itself up in academic centers as something sweeter and cuter than that, but when you really understand what's going on, that's what it is. And strangely enough, there are some number of these activists that I do believe they think they're doing good in some sort of self-deceived way, because they've been taught by people that they trust that this is how you do good for children. However, it is objectively false and harmful, but it has the nature almost of a religion, almost cult-like, in that there's a refusal to hear any counter evidence or counter argument to this belief system. So it's almost religious-like. And that's what we observe with a lot of these activists that are going into school districts and meeting with school board members and meeting with superintendents. They present it in almost an evangelical kind of a way as how you do good, but it's a really crappy religion.
Yeah, I think it's driven by the belief that when a child says, I'm trans, I'm the opposite sex, the only appropriate response is immediate and unquestioning affirmation. I think that's what's driving the heart of this, and anything but that is abusive and harmful to kids.
And otherwise kids will commit suicide.
Yeah, and otherwise kids will hurt themselves, kill themselves, right? And actually, the science doesn't support that. So there's a series of studies that has shown that for the vast majority of kids, we're talking 80 to 90% that deal with gender dysphoria, it goes away naturally, often with puberty. And there's some early research, it's very early, suggesting that transitioning actually affects the rates of persistence. And this makes some sense. It's self-reinforcing, right? If an 11-year-old has all the adults around them that they respect throughout the day saying, yes to the opposite sex, reinforces that belief in their mind and can cause that to persist when it otherwise might not have. And we know from our client, the story I told earlier, and from detransitioners that it isn't always the best thing for them. They tell us themselves that this is actually not what I needed in that moment. So the fact that it isn't always what's best for all kids is part of why parents need to be involved. And I think part of the strategy in the litigation needs to be bring the science to the court and just say, look, this premise on which this is based, that affirmation is the only answer, is just wrong. And the world, science is showing us that it's wrong. And I think the truth is on our side on this one.
And especially since affirmation these days actually means medical intervention. And the idea that you would deny a parent knowledge of medical intervention that's going to be taking place with their child really is just striking. So here's what we'll do. We have about 22 minutes. We'll go ahead and take some questions from the audience. And while people are lining up, let's just go down sort of a fire drill. Give us a little idea of what's the solution here. We got a bunch of different people in the room who either have spheres of influence, whether it's litigation, legislation, or maybe they're just parents who want to be active. What's the best way of addressing this? We'll start with you, Will.
Well, it's multi-pronged, but the first one is look at the success of homeschoolers. We've never been a large percentage. Back when homeschooling was still illegal, 30 years ago, parents in Texas were being thrown in prison, and that wasn't until the Leaper decision in 1994 that stopped. So 2% of the population, they won. Today there's more homeschoolers, but we've got the numbers on our side, so we've got to get out there, tell these stories, school board races, state legislation, federal litigation, keep raising this issue because it is absolutely vitally important to the future of our country, these young people's lives.
Yeah, I don't have much to add. I think it's everything. I mean, I think we keep bringing federal cases, keep bringing state cases, run for school board, show up at your school board meetings, pay attention to what your school policy is, push for legislation in your state. There's lots of different ways to attack this. We need to do them all.
From a litigation standpoint, bring facts that shock the conscience, bring damages claims wherever possible, because these kids oftentimes grow up by the time the federal courts have gone through their long processes, or they have to be taken out of that toxic environment for their own mental health, and then you lose standing if you don't bring a damages claim. Work to create a record that taking action to affirm a child's imagined sexual identity is a life-altering intervention, and strengthen the substantive due process parental right with free exercise claims. We're finding that that's a good combination. That just seems to be a winning combination. And then finally, consider bringing ADA claims, Americans with Disability Claims for violations. In 2023, last year, the Supreme Court decided in Paris versus Sturgis that there is a private right of action for violations of ADA, and most of these kids have significant mental health problems. Target law school, the school districts whose board has flipped because you might actually have some receptiveness for settling on the other side, and create private rights of action. Without a private right of action, the rights that you've created on paper by statute are virtually meaningless. They can't be enforced. So they need to be enforced. So go ahead, go back and create them with fee shifting. That's my prescription.
Thomas, wrap this up.
Yeah, the only thing I'd add is really think through the litigations as much as possible. This is always a good idea for every case, but in particular this one, because when the left cares about something, they'll do whatever they can to keep it. I think, there's going to be concerns about opening Pandora's box by recognizing a parental rights claim and giving it strict scrutiny, and there's going to be a lot of courts with intuition against it. And in particularly bad cases, I think schools are going to do whatever they can to make the case go away. They're going to play mootness games. They're going to try to settle the case. They're going to try to slow it down. They're going to do whatever they can to not make their case the case. It's my experience. I sue universities and K through 12 schools all the time. They will work hard. We have to be smarter. We have to work harder on it because we have the right cause on this, and we need to win this. So that's the last thing.
One quick thing I would just add that I thought of, I forgot to mention. So just in the nuts and bolts, I think it really helps to have both a parent who is injured retrospectively and a parent who is suing prospectively. In the one case that we won, it just made it really awkward for the school district. They filed a motion to dismiss saying, you can't sue, it's too soon, and you can't sue, it's too late. And the judge, and it was like, well, it can't be both, right? Because then no one can sue. So we won the motion to dismiss on both of them because it was just so obvious, the sort of trap that they were trying to create.
Thank you. Let's go to the audience for questions.
Thank you. My name's David DeLugas. I'm with Parents USA. Luke, in the case pending before the Supreme Court distributed for September 30th, a question would be, what makes you think they'll grant cert in that case when the Montgomery County school case earlier this year, they denied it? And I wanted to point out, in that case, we've submitted an amicus brief. Sorry, we weren't aware of your case. But here's the question. Everybody assumes that if a student mentions gender confusion, they're telling the truth. And if they mention that they're not going to be received well at home, they're telling the truth. Both of those are assumptions we're all making, which we should not. And as I wrote in our brief, quote, my dog ate my homework, students throughout history, we should not have a policy anywhere relying only on one side of the story. The child may be saying they have this confusion based on currying favor among peers, with teachers, and it's just a lie. Or they are confused and they tell the lie about the receptivity at home because they like the attention or they want to, again, curry favor, where in fact the loving parents at home may say, we love our child, thank you for letting us know, we'll deal with it. But and Bernadette's point, absolutely 100%. Schools are not equipped to investigate. They don't have the authority. They don't have the expertise. Turn it over to law enforcement, CPS. If you believe a child is at risk of being harmed by virtue of their gender decision or confusion, if they're going to be harmed at home, that's not the role of government or of schools to participate in determining whether or not there's harm and then dealing with that risk of harm.
Yeah, so to the initial question, the U.S. Supreme Court denied cert in a case that was postured very similarly to ours. Parents sued preemptively, they lost on standing, the court denied cert without any comments or dissent. So there's a decent chance that's going to be the outcome in our case too. We do have some different arguments for standing, but look, I think we need to keep going to the court over and over and over again, and I think the court needs to see and hear all the stories of what's happening to young people around the country. And again, there's 35 to 40 of these, so it's hard to imagine 35 cert petitions and not one of them getting granted. Each time there's going to be more lower court decisions, there's going to be more chaos in the federal court system, and it's going to split the courts in a lot of different ways. It already is. So maybe it's not our case, but it will be some case eventually. And part of what I tried to do was just set the stage and say, here's the story of all the litigation that's happening around the country, to maybe prime the court for a future cert petition, even if it's not ours.
And candidly, I believe the case is a case in which a child has actually been harmed will be the more compelling case. Sorry, Luke. Sorry. We'll support each other. but I just think that from a human, it's going to probably be the more compelling case, and my guess is that that probably will be the first to break the ceiling. But anyways, question.
Next question, and remember, end your comments with a question, upward inflection.
Okay, I have two brief comments and then my question. My first comment is that I'm on the school board. I'm on the 6th largest school board in the country, and I was amazed when I went to a statewide training. One of the questions that was asked is, how do you get around having to tell the parents that we're transitioning their child? I mean, my jaw wanted to fall just to the ground. And the coach said, who was an attorney, you started out with the child is depressed, they're having difficulty with socializing with other students, and then that is not the foremost front-runner issues. You bring it in later and slide it in so it's not there on black and white up front. So that's one reason they're getting around. Second thing is, we have a manual. I found the manual, okay? If you find anything on their websites, download it, because it will disappear or it will change, and you will not know what happened to that language that was in there. So make sure you get that, keep that, that's your evidence. Now to my question. I often thought about, how do I address this issue? And I kept going back to the Hatch Act. Why can't I create a letter that puts out here that you're recognizing this is a parental right and a fundamental right, okay? We start from there and we just keep building on. I have all kinds of notes, but I don't have to go through them. And that if something happens with my child, this is a medical issue, not an educational issue. My phone better be blowing up, and we will address the mental and the medical issues by the practitioner that we select.
Right.
Okay, and that if we preempt this all in front of them and say, and choose that person in the best interest of our child, throw in all the buzzwords, and then take that to the school and say, I want you to sign it. If they won't sign it, don't go to that school. Right now, we're down 50,000 students in our school. They're leaving, homeschool, private school. They're just charter schools. But if we can get the numbers, we can rein this in, because they can't afford to not have our tax money there. They need it. We're struggling. We might go under because we've lost that many students. So take the power back and make it contractual. I'm relying on this in order to enroll my student and select this school. And then you have your reliance argument. So you have a breach of contract with them too. So anyway.
Is that a viable option?
No, I don't think they're going to sign the letter. However, we have a letter. You're welcome to go onto our website.
Okay.
We call it we've drafted, after many of these situations, a parental notification letter that we have given as a template to parents and encourage them to send it. And it basically says, we are the parent of such and such child. We have done our research. We're fully apprised of the science and the medicine behind this. Here's our family's value system. Here's our religious beliefs on this issue. And so therefore, if our child ever identifies as anything other than his or her sex, that we are to be notified immediately within 24 hours. We're also instructing you, well, I don't say rest, instructing you that you are to never take any actions to affirm or endorse our child's gender confusion. If our child ever expresses the desire to be treated as something other than the sex, you are not permitted to take any actions to affirm or endorse that. We would consider that harm to our child and harm to our family, and there's actually a few more provisions to that. Copy your family's attorney and send it in some way that you have proof that they have received it. So anyways, I know.
Now you're talking. That's what we need. We need to be preemptive.
I would think what you described would matter, right? If you come to a school district and say, here's the child's psychologist who agrees with us that this is going to harm them, then the school would respect the decision, but that's actually the facts in a number of the cases around the country, and the school still ignored the parents.
But the reason why I think that letter matters, though, is because, number one, you actually do. School officials tend to be conflict averse. So if you've gone to the trouble to create a well-worded letter like that, 8, 9 times out of 10, they'll go pick on some other person that's just easier to deal with. But also, it's to help set up the evidence that will help you prevail if you actually do have to file a lawsuit. There's reasons we put each provision in. I'm sorry, I know there are more questions, but.
No, thank you so much.
Next question, thank you.
My name's Paul Kanag. I'm an attorney in Connecticut. So we have another dimension that you haven't talked about, and that is we have the Department of Children and Families, and what happens is the school or the kid contacts the Department of Children and Families and complains that the parent is not agreeing to whatever the kid wants to do, the gender transition. And then asks the Department of Children and Families to terminate the parents' rights. And in Connecticut, which is, a very blue state, there's a lot of support for that, and it's become a big problem. It's a way for kids, even if the parents don't agree, to force their way into gender transition. Sometimes the parents will just give in and recognize that they have a choice between losing custody or acquiescing. So how do you deal with that?
That's terrifying, and that's what's coming, right? I mean, and to the point we made earlier, that's why we think this is the most important civil rights issue of our time. If the school can do this because there are no parental rights, then government can do that, and that's terrifying. And I think, any of us up here would happily litigate one of those cases if it came up. So, call us or any of the number of other organizations that are litigating these cases.
If you go on our website, you'll find a resource that we have written, what parents should do in dealing with child protective services. I have litigated these cases. I'm litigating one right now in California, and they're very difficult, but there are steps that can be taken to, first of all, keep the child out of care to begin with, and then once they do get into care, how to handle. They're very difficult. But there is a resource that we have written based upon our actual in-court experience. It's childparentrights.org, childparentrights.org, and then look at the resources tab.
Next question.
Yes, I'm curious if you could comment on what you think the significance of the Skermetti case that the Supreme Court's going to hear in probably December on the Tennessee law that bans transitioning minors with surgery and hormones, et cetera. And specifically, does it concern you that the Sixth Circuit upheld it and they still granted cert? And then the other thing is there significance, do you see, that they granted the Biden administration cert petition on the equal protection claim as gender identity a suspect class, but did not accept the ACLU's cert petition in the same case on the parental rights? I think, and Luke was alluding to this, on the, parents have the right to transition your kids. So just talk about Skermetti. Thank you.
Thomas, do you want to take that?
Okay,
Or
so
Bernadette?
oh yeah, he probably can.
Yeah,
I can.
Go ahead.
Oh, all right. Skermetti is of monumental importance. I think the only other case that when it finally fully gets to the Supreme Court that'll come close is another Tennessee case, Tennessee versus Cardona, on the Title IX regulations. That's not yet fully been granted cert, but those two. But Skermetti is one of the two that I think is going to establish whether this area is constitutionalized in the wrong way, whether it's reified, the idea of this legal fiction called gender identity is a thing in law that has to be protected constitutionally. And I was actually encouraged by the fact that they upheld, sort of in the interim, the stay in the interim that the Sixth Circuit had put into place. They didn't automatically remove the stay, which I believe is more often when while it's pending. That was encouraging to me. What was the other part of the question? What was the other part?
They didn't grant the parental rights
Ah.
petition from the ACLU.
Yeah, I was fascinated by that. I mean, honestly, I was kind of gobsmacked. I don't understand that versus the equal protection. I think okay, all right. So I think probably because it's a little bit more clear that this is not a parental right. So let's go ahead and leave it in place because the Sixth Circuit said it wasn't. So there's no reason to get into that quagmire because they basically feel it's not a parental right to do this to a child. There was a very good record. Well, excuse me, there wasn't a record. That was Alabama. Whereas in equal protection, it's an opportunity to finally clarify whether this class of individuals is a suspect class, which is based on the question of whether this is the characteristic at issue is innate and immutable. I'm optimistic. I believe they're going to say no because it's palpably not innate and immutable. And I think the detransitionist amicus briefs are really important to establish that. It's fluid. It's rapidly fluid with a lot of regret. Clearly there's no evidence it's innate. So I'm really hoping they're seeing this as an opportunity to finally clarify that it is not a suspect class, and that will get rid of a lot of mischief in the process. But a lot of prayer is required in the meantime.
Next question.
Hey folks, John Tyler, longtime listener, first time caller. I'm a product of homeschooling, homeschool dad, but my day job is general counsel for the South Carolina Department of Education. And in my role, I regularly meet with school administrators, school board members. I go to their conferences, and I see the fear that they have about the phrase parental rights. So my question is, how do we win over school boards and school administrators? I mean, litigation obviously is part of that. But more importantly, maybe, how do we empower the good ones to speak up? Because there is a silent group of people out there that don't want to be ostracized in their community, that if they could just speak up, they would actually find that there are a lot of others that agree with them.
Will, you want to take that one?
I think the problem goes to what Bernadette said of to whom do children belong? Is it the state or is it parents? And that's the problem, because I deal with this all the time with homeschool legal defense, where parents are saying we want to withdraw our child from public school, and I've had superintendents tell me, nope, we don't think this parent can homeschool. It's our child. We have to make sure. And so at the end of the day, it's very tough for a lot of public educators, and I say this, my dad spent 37 years as a special education teacher in New York and Pennsylvania, because they're ingrained, this goes back to, Dewey and everyone, they're ingrained that they're all our kids, it takes a village, blah, blah, blah sort of thing. And we have to remind them that, no, parents love their children. They love their children more than you do. You are a steward of that. And it's a partnership between, when kids are in public school, it's a partnership between the parents and the teachers. And a good teacher recognizes that. It's the newer crop of administrators and teachers where they've been indoctrinated that all parents are bad, they abuse their kids, they don't love their kids, blah, blah, blah. We are the trusted adults in the room. And it's an education thing of reminding them, no, parents love their kids. You are a steward of that. That's my thinking. Education.
Yeah, absolutely. Well, I think we're out of time, unfortunately. Our panelists are going to be up here, so if you didn't get a chance to ask your question, make sure you come talk to them. But if you could, please give our panelists a round of applause.
What a really nice, hopeful note to end on. Thank you again to Ben and our panel, and to all of you for being here today at the 3rd Annual Education Law and Policy Conference. But the day is not quite over yet. We've got a closing reception that is down the hall in the Chinese room. You'll see the DFI sign. It's right next door to the room where we had lunch, and we'll see you all there soon.